Good afternoon, everyone. It's my pleasure, my name is Matthew Boswell, first and foremost, to moderate the merger plenary session of this year's conference. Before I get us going, though, I do want to take a moment, like others have, to thank Sarah and Eleni and the whole CMA team for hosting us here in Edinburgh, and for the kind hospitality they showed us last night at the beautiful Mansfield Trancaire. I think I'm pronouncing it right. It was very, very generous. So I'm delighted to introduce our great panel to end the morning. Longer descriptions for each person's background is available in the materials, so I'll be relatively brief. Starting at the far end, someone who you've already met this morning, Guillaume Loriot, is the Deputy Director General for Mergers at DG Comp. Beside Guillaume, Rachel Brandenburger, who's a visiting research fellow at the University of Oxford's Institute of European and Comparative Law. Another double duty person this morning is Andrea Marván, who's the chair of the Mexican Federal Economic Competition Commission, also known as COFECE. And finally, to my immediate left, is Commissioner Ya-Lun from the Taiwan Fair Trade Commission. So we have a great group. And let's get started by setting the stage a bit for the discussion today. Our topic, as you heard from Sarah, is entrenchment theories of harm in merger reviews. And this is an issue that is arising more frequently in merger reviews around the world. So very important for us to discuss. In fact, among a whole slew of amendments to Canada's merger law, we had an amendment that requires or gives the court the option to consider whether the merger or proposed merger would contribute to the entrenchment of the market position of leading incumbents. So we, in Canada, we're in the process of revising our merger enforcement guidelines. We've put out a discussion paper that talks about entrenchment, and we anticipate providing more guidance through our guidelines on this particular issue. And of course, just by way of sort of historical background, entrenchment theories of harm are not new. In the United States, they go back to the 60s and 70s, the entrenchment doctrine coming out of the Procter & Gamble conglomerate case. They've been considered in different jurisdictions around the world. And there are, as I'm sure there are in this room, differing views on this theory, pro and con. Entrenchment can be relevant in the assessment of horizontal mergers as well as the non-horizontal effects of mergers. Some people argue that mergers can entrench dominance by raising barriers to entry, restricting rivals' opportunities, and eliminating nascent competitive threats. In today's session, we're going to hear how authorities are approaching theories of harm related to entrenchment, the challenges that authorities can face, and how, in practice, the different aspects of the broader entrenchment theory have been applied. So, let's get our panelists involved now. We're first going to tackle what frameworks are used to think about entrenchment. What role, that is to say, what role does merger control play in preventing the entrenchment of dominant firms? And what elements should agencies consider? That is, what is the framework that agencies apply to consider the issue of entrenchment? And I'm going to start with you, Commissioner Yen. How does the TFTC approach entrenchment? And how does Taiwan's Fair Trade Act regulate mergers involving what we would call entrenchment strategies?
Okay, thank you. And distinguished colleague and participant, it's an honor to join this panel at the 2025 ICN annual conference today. I'm pleased to share Taiwan's experience and perspective on this important topic, particularly how we approach entrenchment theory in our merger analysis framework. Although the term entrenchment is not explicitly defined in Taiwan Fair Trade Act, the TFTC examined whether mergers could entrench a firm's market power or strengthen barriers to entry. And entrenchment may refer to actions, measures, and strategies that increase, maintain, or solidify a firm's market power or competitive advantages, while discouraging entry from rivals. And the key sources of entrenchment include low-cost production advantages, high switch cost, network effects, intangible assets, and efficient scale. In the TFTC's merger review process, we pay particular attention to how these factors involve in the digital economy. And digital platforms operate in fast-moving, multi-sided markets characterized by strong network effects and data accumulation advantage. And this platform often provides service without monetary pricing while building ecosystem that extend across multiple markets. And when evaluating mergers involving digital platforms, we carefully assess how economy of scale and network effects might serve as sources of entrenchment, potentially creating formidable barriers to entry. The TFTC has observed that the importance of network effects dynamics further amplified by big data, and where data serves as both a critical asset and an essential input for algorithm systems. Additionally, TFTC analysis extends to vertical and conglomerate effects, especially when assessing how digital platforms might threaten their economy moats through strategy acquisition that reinforce their ecosystem advantage. In general, while identifying and substantiating entrenchment theory of harm in specific case present practical challenges, this framework offers a valuable perspective for assessing competitive concern in mergers, particularly in digital markets characterized by strong network effects and data, as well as ecosystem advantage. Thank you.
Thank you, Commissioner Yen. Rachel, let me turn to you here. And you heard me make reference to some of the history of entrenchment theories. In your view, is what we're talking about now a new theory of harm, or is it a repackaging of what was being talked about in the 60s and 70s?
Thank you so much for the question. And let me also start by thanking the CMA most sincerely for the privilege of inviting me to this annual meeting and to be participating in this panel as an NGA. I think the answer to your question, Matthew, is both, or all three. I lost count, actually. I mean, we know that merger theory in terms of the creation or strengthening of a dominant position is a theme that is well recognized in many jurisdictions around the world. These days we are also hearing about entrenchment of a dominant or monopoly position, which is used not in relation to whether the acquirer with the monopoly position is acquiring a company with either a horizontal or a vertical relationship with the dominant player, but more an acquisition of a company that may have complementary products or services to the purchaser, and the purchaser is seeking to obtain an ecosystem or to build a moat around its dominant position. Now, I've just threaded various phrases and labels into that explanation. Let's focus on entrenchment here. No, it's not a new harm, as your opening remarks recognized. There is an important case, the FTC's challenge of Procter & Gamble back in 1967, the US Supreme Court's judgment in that case. This involved Procter & Gamble's acquisition of Clorox, which the parties called a product extension merger. the products didn't overlap. Procter & Gamble made packaged detergents, as it still does. Clorox made liquid bleach, as it still does. And the issue was, were the barriers to entry being raised? And I'd just like to give you a few quotes from this judgment, which I think are quite interesting. So let me quote from these. The Supreme Court said, "It is clear that the existence of Procter at the edge of the industry exerted considerable influence on the market." First, the court said that each of the parties influenced the market behavior of competitors, actual and potential. That there were not significant barriers to entry. Procter could have entered the market that Clorox was in, and that the merger would involve the elimination of a potential entrant. Few firms, said the court, would have the temerity to challenge a firm as solidly entrenched as Clorox. And the court found that Procter was the most likely entrant, and that the US FTC had had evidence in front of it that justified the prohibition of the deal. So you can find here various themes that we talk about all these years later. The significance of what we now call the entrenchment theory has fluctuated over time in terms of agencies and academics' interest in the topic. These days it's very much center stage, as this panel is showing. And let me also just note that it is beginning to feature in merger guidelines as well. The UK merger guidelines were very much forerunners in talking about potential competition generally. US merger guidelines, I'll leave to you, Guillaume, if you wish to, or, sorry, the EU, indeed, yes. I'm sorry, that was a Freudian slip. US guidelines is what I would like to just finish on here, which is where the 2023 guidelines, the new guidelines, specifically address entrenchment. Guideline 6, which notes both an entrenchment of an already dominant position or an extension of a dominant position into a new market. So two-pronged approach there. And then the guideline goes on to talk about the potential anti-competitive effects, but also noting that there can be pro-competitive benefits. So that takes us into a whole nother territory of how do you balance those out, and how do you find the evidence to support your findings. Let me leave it there.
And that reflects some of the debates over the 80s and 90s in the United States on this issue. So let's turn to our friends from Mexico. How do you, at a sort of a high level, Andrea, how do you folks think about entrenchment and approach it where you might see it in a case?
Yes, thank you. I would only just second and appraise the CMA and Sarah and Eleni for doing an excellent job organizing this wonderful event. I would say our approach is very similar to what Commissioner Yen was saying, and I will focus for now specifically on our merger review. So when we review mergers, what we look at, or what we are seeking, is to prevent market structures that may harm or hinder competition. And now our law has, I would say, a comprehensive approach. Since we can block a merger under 3 circumstances, and I would say that 2 can be related to entrenchment. So the first is when the transaction creates or strengthens substantial market power. The second is when it can facilitate collusive conduct. And the third is when it may have the purpose or the effect of creating barriers to entry, impeding access, or excluding competitors. So I think when we look at entrenchment theories of harm in our merger reviews, I would say that the strengthening of market power and also the effect of creating barriers to entry or raising those barriers or impeding access is related to entrenchment. So what we do when we conduct our merger review is I'm sorry, I got lost a little bit. Yeah. Okay. So what we do is a combination very similar to what Commissioner Yen was saying, because we also look at the potential elimination of potential competitors. We look at ecosystem effects. We look at conglomerate structures, and also, which is something that the Commissioner Yen mentioned, to access to sensitive data or information. I would say, and I think it's very relevant to bring to the discussion, is this new or is it not new? And this is something that I will briefly talk about in my next intervention. But we've looked at these theories not only in digital markets, but also in traditional markets. I know it's been gaining more relevance in the digital discussion due to the strong network effects that come with the digital economics and the risks of market tipping. But again, I think these theories can be applicable to both traditional and digital markets. And I'll talk about that in my next intervention. Thank you.
Okay, thank you, Andrea. So how does this translate into practice is our next sort of general area of conversation. As you've already heard, entrenchment considerations can become particularly relevant in the context of digital mergers, and Commissioner Yen and Andrea talked about that. But as we heard from Rachel, wider applications, bricks and mortar type mergers. So different members of our panel have different experience dealing with entrenchment theories of harm in real life in merger reviews. And with that, let me first turn to Guillaume and ask for you to share with the audience DG Comp's experience with the consideration of these theories. How have they been looked at in specific cases, if you can provide specific examples? And have you seen examples of proposed mergers that have come before DG Comp where the entrenchment theories have been used to block the merger or to raise concerns?
Thank you, Matthew, and thank you for having me on this panel. I mean, a lot has been said already a bit on the framework, what is new, what is not new. I think what is not new is when you talk about entrenchment, essentially you're talking about a company having market power and consolidating that market power in EU terms, strengthening its dominant position, consolidating this position. And obviously that may sound not so new. You have the traditional horizontal mergers with the acquisition notably of a potential competitor, with a strengthening of a dominant position, a pure horizontal effect. That is well known, but I think is being articulated under new market realities indeed. What we've seen as being new, and that's about experience, is those mergers that are non-horizontal, where you have a company being very strong on its core market, as we say, being dominant, acquiring a firm in a neighboring market with specific features, and that will be one type of discussion. And despite having no overlap, the question is, do we look at it under a traditional non-horizontal assessment, which still remains the main way of assessing it? Is the company leveraging its dominant position to a neighboring market in order to foreclose it to rivals? And foreclosure, requires some types of strategies, conducts, from tying to, hampering interoperability, etc. In digital or other markets, I mean, that is very important. And that remains, I think, very relevant. That's the main way of looking at non-horizontal effects. That being said, we've seen from experience that there's also a question whether the rationale of the merger is not simply to protect the core market in which you are dominant by acquiring this complementary asset because of the specific qualities, capacities that this company has in a specific market context. So that is, I think, what is new and relevant, especially, but not only, in a digital ecosystem because of the strong complementarity, the interoperability, the interconnection between markets. I think that's the setting. And this setting existed before. If I think about Google DoubleClick in 2007, I think we focused a lot on foreclosure in this very complex merger. But the question had been raised and was not really looked at in that and under that angle. And that is, I think, relevant today. Now, we had experience. We had several cases where the question arose. We had Google Fitbit, for example, where there were issues about interoperability in adjacent markets, traditional way of looking at things, but there was also the question of whether, some data coming from Fitbit would strengthen Google on its, ad markets. And more recently, we had a case that is very prominent, which is in court, which is Booking eTraveli. I think we mentioned one of these gatekeepers coming from Europe. Now, in that specific case, for many reasons, but one of which is that in that ecosystem of online travel that we see developing, you have the hotel OTA, but you have also the flight OTA, and the acquisition involved a source of significant traffic through customer acquisition, because that company, then number 2, now number 1, was a way to enter and to expand into the market we're booking in Europe is, we think, dominant. And we found, because of various specificities, customer inertia, the fact that people don't switch, they go in and they stay, we have figures and so on, various features about these complementarities have, we think, the likely effect of strengthening Booking's position on its core market. So now, we think that irrespective of any conduct, and I think that's also a new discussion to have in a non-horizontal merger where you have a type of effect which is a bit similar to a horizontal effect mechanically because of the market features, because of this flywheel effect that one can observe, you get more customers, you get more traction, and that has the impact of strengthening of dominant position. That's the key discussion we may have, and we will have in the review of our guidelines, in court, in Booking, and more generally amongst competition agencies. And it's very important to address it. There are other scenarios. And I think there's a case that I want to mention. There are other cases, maybe I will come to them later. Another case we had recently, which is NVIDIA Run AI. Very topical, we discussed AI and so on, non-horizontal merger, a case that was referred to the Commission by the Italian competition authorities. Many, you tick many boxes about the importance of that case. And at the time, we wondered, NVIDIA is, we think, potentially dominant, in fact, dominant in this very specific market of GPUs for data centers, specific type of chip, and was acquiring a type of software that allows you to optimize these GPUs. I don't want to go into the technical details because that's quite complex. And obviously we wondered, okay, let's look at whether there's an issue about leveraging your dominant position into this adjacent market, but is it also a way for NVIDIA to strengthen its dominant position through the acquisition of a company in an adjacent market? And we investigated very thoroughly, I can tell you, because we thought that indeed that might be another example of entrenchment. And after going to the market and considering different types of strategies, here not really an automatic kind of horizontal effect, but more foreclosure strategy for various reasons as to whether essentially by hampering the access to this orchestration software for competing chip manufacturers, that would ultimately strengthen NVIDIA's position. And we reached the conclusion that no, it wasn't the case, it wasn't likely. Why? Because rivals of Run AI, so rivals of the target, that may be the first to fear any strengthening of dominant position, were telling us that in the market it's simply unlikely that NVIDIA could restrict access and interoperability to this software, because there are many standards and tools to make sure that and it's difficult to discriminate because of various reasons. And the conclusion was quite striking. And that doesn't mean we shouldn't have done it. I think on the contrary, we should have looked, and it's very important to look at whether a non-horizontal merger may not only lead to foreclosure in adjacent markets, but may strengthen the position of a dominant player in its main market. So obviously many factors matter, market features, market trends, customer behavior, customer inertia potentially, and that is relevant in digital ecosystems, but well beyond. I think we have to think about how it may impact other markets. Now there are many examples, there are some examples of other cases we looked into where we didn't reach the conclusion of an entrenchment. Still we looked at that, and maybe it will help us to have some specific criteria for the future in our merger guidelines notably, but also to explain to courts why there is a way to distinguish the impact of such mergers on entrenchment. So that's my point in terms of experience, and I guess we'll develop.
Thank you, Guillaume. It's actually right at the end. You gave a great lead into the question I want to ask Rachel. In 2025, is this theory, and this is maybe a bit of a rhetorical question, is this theory only relevant in digital markets, or does it still apply outside of digital markets? Because we've heard about a lot of digital markets cases, but is it still broadly applicable?
Well, I could duck your question by saying, well, time will tell, but I will. I mean, we certainly are hearing a lot about it in the context of digital markets. But let me put on the table an example outside the digital space, in the pharmaceuticals sector, where the US FTC, and I don't quite know why all my examples are coming from the US FTC, but 2 years ago, Amgen Therapeutics sought to acquire Horizon, and the FTC challenged that merger, the first time that they had actually litigated a pharmaceutical merger for over a decade, and sought to block the merger. The FTC described Amgen as one of the world's largest biopharmaceutical companies. And very briefly, the FTC claimed that the acquisition would enable Amgen to do two things. One was a leverage claim, that in its large portfolio, if it added to what the FTC called monopoly products that Horizon produced, one relating to the treatment of thyroid eye disease and the other relating to chronic refractory gout, into their large portfolio, this would have a leverage effect. But there's also was a claim that is much more akin to an entrenchment claim, that by substituting Amgen's, what the FTC called, broad and powerful portfolio with these two allegedly monopoly products, a much broader portfolio than Horizon's portfolio, this would raise entry barriers and make competition by other producers much harder. Well, we don't have a complete answer here, because this case did not litigate in the end. It was settled by the parties with the FTC, and that resolved the potential competition harm. If you look at the settlement, you find a combination of the sort of usual, if I can say it, bundling, anti-bundling type provisions, together with more specific provisions that address the alleged entrenchment theory. I would note these are behavioral type conditions in a merger context. That's sort of going off at a side, but it's an interesting point. There was a trustee put in place for monitoring compliance with the settlement. So as a settlement, it's not binding precedent, but it's perhaps, and maybe the panel can correct me here, the only recent court judgment in this area.
Okay, thank you, Rachel. Let's turn back to Mexico. I understand in 2020 you had a merger review that brought up entrenchment theories. Can you tell the audience a bit how you worked your way through those, what the specifics were?
Yes, I'll be very, very happy to. But before I turn into that specific case, I would just like to second what Guillaume was mentioning, that you usually see our decision, you usually have we have extensive decisions where we block or we impose remedies on a merger, but that doesn't mean that we don't test entrenchment theories in many other mergers. So we've had mergers mostly related to fintech and bank sectors, or online booking websites, etc., where we tested those theories, and it resulted that there was no risk, so we actually approved the merger. merger. But now looking into specific cases, first, I wanted to address a case which is related to digital, where Walmart wanted to acquire, which is, we all know who Walmart is, but in Mexico specifically, it's one of the largest grocery store retailer by far. And so it proposed to acquire Corner Shop, which is a digital platform for grocery display, purchase, and delivery via a mobile app. So although the company, and I think this is where entrenchment becomes relevant or part of the analysis, they both operated it in different segments. You had a very big retailer and then a very big digital intermediary or a platform. So our analysis and our conclusions were that there were serious entrenchment risks stemming from this vertical integration. So first, what we concluded is that that transaction would have granted Walmart access to very sensitive commercial information about its competitors, because the platform didn't only act as an intermediary for Walmart, but for many other grocery stores. So it would have access to data such as pricing strategies, discounting behavior, consumer profiles, etc. Also, as the operator of the platform where other rival grocery stores participated, then Walmart could have used this privileged information to participate or undermine competitors, not just within the app market, but also in a broader market. Additionally, Walmart, which as I mentioned is by far the largest grocery store in Mexico, could have leveraged this position to foreclose competing delivery platforms, specifically to refuse to participate in other apps or to offer exclusive benefits for those who participate in this app. So in essence, what we concluded with this transaction would have cemented Walmart's dominance by commanding its massive brick and mortar footprint with control over a key digital access point. So, and also which ultimately will be creating very high barriers to entry for new players, or reinforcing locking across the grocery ecosystem. So given those considerations, COFECE decided to block this merger. And I think this case is very clear because it combines entrenchment theory in, as I mentioned, digital cases.
Okay. Commissioner Yen, going back to you, how does the TFTC, how have you, dealt with this in real life?
Thank you. As for this issue, I would like to illustrate the TFTC approach through several cases that highlight how the TFTC has applied entrenchment theories of harm in practice. The first case is a Microsoft acquisition of Nokia Device and Service Division in 2014. This is a vertical merger, and this merger involved mobile operating system with characteristics of two-sided markets and network effects. And while we recognize that post-merger, Microsoft's expansion in the Windows Phone installation base will potentially create a third ecosystem alongside Google and Apple. However, we identify significant concern by reducing dependence on third-party device manufacturers. Microsoft might have increased incentives to raise royalties under its Android licensing program. This could increase royalty expenses for device manufacturers using the Android system, elevating downstream competitors' cost and potentially leading to higher mobile device prices. And turning to our second example, the TFTC examined two separate but related mergers in the mobile payment sector. The Alliance Digital Technology Corporation case in 2013 and the Taiwan Mobile Payments case in 2014. Where the TFTC addressed conglomerate merger involving firms with significant market power in existing but different markets to establish joint ventures for operating trusted payment service manager platforms. In both cases, the TFTC primary concerns was whether these firms could extend their existing market power to the emerging mobile payment platform business. And for a more recent example, just in December 2024, the TFTC prohibited the merger between Uber Eats and Foodpanda, the two largest food delivery platforms in Taiwan. The food delivery platform market faces structural entry barrier due to economy of scale and the chicken or egg paradox characteristic of two-sided markets. The TFTC concluded that post-merger, Uber Eats could generate stronger network effects than before, making it more difficult for potential competitors to overcome this economy moat. And by signing exclusive agreement with key restaurants, Uber Eats could exclude new entrants from the market. And furthermore, after merger, Uber Eats enhanced access to consumer and restaurant data, would create more data-driven advantage, further entrenching its dominant position. And the TFTC market analysis also revealed that Taiwan's food delivery platform market has a minimum viable scale, requiring partnerships with over 450,000 restaurants and 6.5 million consumers. And a few new entrants had successfully penetrated this market in recent years. And while several existing operators had existed. Finally, the TFTC determined that potential competitors would not be able to enter Taiwan's food delivery platform market in a timely and sufficient manner to exert competitive pressure on Uber Eats equal to the currently provided by Foodpanda. And this is a very tough decision for us to prohibit this merger. Yeah.
That's a great example. Thank you, Commissioner Yen, and recent. So now let's move on. As I said at the outset, one of the things we're going to talk about is challenges that competition authorities face when dealing with these theories. And Guillaume, you referred to this in your earlier comments. Perhaps you could discuss the difficulties in identifying sort of clear limiting principles when you're looking at these, because the debate and the historical debate has always been, it could be pro-competitive, but it also, could tend towards harming and entrenching. So it's difficult to get into the weeds on this and find those limiting principles that agencies have to look to.
Thank you, Matthew. Well, first, I don't pretend to have, the response, definitive answer to your question. Obviously, there's there are recommended practices actually that we will adopt on this issue, but there's also, ongoing debates, as I said, ongoing reviews of guidelines, including the EU, and ongoing debates in front of the courts. So that's, what I can tell you is a bit what I see at this moment as issues that are critical, or that have been critical in, setting some boundaries. I think your question is important also because indeed one must acknowledge that one point that may be made in front of competition enforcers that, the acquisition may improve in the short term the offering of the merging party by, they get more data, they can expand the offering to more users. Is that sufficient? Is it good in itself? So there's this discussion to have and to bear in mind. What we're concerned about is that in the, foreseeable future, rivals would not have, available counter strategies to overcome the barriers to entry or to expansion that one would identify as a competition enforcer as being the real issue because of that merger. And I have in mind still the type of cases I mentioned to you. Now, what I see as critical, issues, obviously, first is to understand to what extent the type of assets or the type of activity that the target has in a non-horizontal setting where, there's a dominant position potentially and this target has an activity not necessarily very important, but still in terms of volume, but still potentially qualitatively important, to what extent these assets are important for the companies in its core markets. Is it about IP? Is it about other assets? Is it about customer traffic? So you have the issue of the qualitative significance. You have the issue about to what extent it's really interconnected, complementary to the market, which is the core market. And that's why it's very relevant in digital business, in digital markets, but beyond that as well. I think that's a very critical question. And also, to what extent the asset you're acquiring cannot be easily, you know, replicated in a way, to what extent, and that's part of the counter strategy issue. Now, if you see, and we had this experience, that the asset that is being acquired, the target that is being acquired, does not significantly change the position, frankly, of the acquirer. I think there's no issue. We had this issue in a case that is not very well known, which is the Google Photomath case, where Google acquired an application for users for math to improve on their knowledge about math, the type of app I should use, you see. And then, you know, we investigated and we saw that there were many features that, you know, led to the conclusion that it was not likely to strengthen Google's already very strong position on search, because it was not a very important source of acquiring customers. You know, it's not that these, you know, people looking for math apps would go through search and vice versa and so on. And we had this feedback from the market, also previous experience, as well as, you know, counter strategies available to competitors. That is very concrete, very, very, you know, practical. The app essentially had not a very strong relevance for the core market, if I simplify things. Now, what is important is that in all these cases, you need to look beyond, and that's a bit the discussion we had earlier about, you know, static and, you know, quantifiable effects. You have to be a bit qualitative. You have to look at, you know, in the long term, you know, in dynamic effects, which is a very relevant discussion beyond entrenchment these days. We had this discussion for merger enforcement, so it's, you know, it's a challenge. But that's the mindset one should have. I think what is important is that you're in a situation where you have a company that is already dominant in a market. So competition is not, you know, might be easily or more easily hampered when you look at these type of transactions. So you need to protect the, you know, the limited amount of competition you may have. And that is something that you should not forget. It doesn't mean that every type of acquisitions should be, you know, blocked. We haven't done that. You need to find criteria. You need to find limiting principles. You need a consistent story and a narrative. These are the elements I can share with you that I've seen for now, but obviously this is not exhaustive. We will have further experience in the years to come, and that's why this type of exchange is obviously fundamental for now.
Okay. Thanks, Guillaume. And Commissioner Yen, how do you in Taiwan mitigate or deal with these particular thresholds and limits on the theory?
Thank you. And the TFTC has developed a range of remedial approaches to address entrenchment concerns identified during merger reviews. And led us back to the cases I have mentioned. In the Microsoft and the Nokia case, the TFTC imposed conditions prohibiting Microsoft from inappropriate pricing decisions or discriminatory treatment in patent licensing related to smart mobile device that would hinder manufacturers' freedom to choose mobile operating systems. And this behavioral remedy directly addressed the risk that Microsoft might adopt a strategy to raise downstream competitors' costs. And for the mobile payment platform cases, our remedies focus on preventing ecosystem foreclosures in an emerging market. In the Alliance Digital Technology case, the TFTC mandated that the newly established joint venture and the merging parties not refuse requests for interconnection and interfacing with other mobile payment platforms without justifiable reasons. And similarly, in the Taiwan mobile payment case, the TFTC required that the new enterprise and not restrict service provider from joining other trusted service manager platforms. And these access and interoperability-oriented remedies were designed specifically to prevent entrenchment strategies that could foreclose competition in an emerging market while allowing the merger to materialize the efficiency. In contrast with the Uber Eats and the Foodpanda case, the TFTC determined that no remedies would sufficiently address the entrenchment concerns. The main reason is that the combination of already strong network effects, the minimum viable scale requirements, and the late growth phase of the market indicated that any post-merger entrenchment would be extremely difficult to reverse. And the merger would create economy modes through data advantages and the network effects that would be insurmountable for potential competitors. In such cases, where no effective remedy exists to mitigate entrenchment effects, prohibition remains the appropriate solution. And I think our collective experience in this area can help develop more robust approach to merger reviews as market continue to evolve. Thank you.
Okay, thank you, Commissioner Yan. So there was, I guess on the Uber Eats, it was just too many behavioral remedies would have been required to fix the situation. Okay, we're running low on time, but to get towards the finish of this, let's look ahead to best practices and strategies. And I have a series of questions that I'll just put out there, and then I'll direct or ask a couple of people to help us look ahead. So the questions are there any specific elements agencies should consider with regards to entrenchment theories of harm in the merger context? Are amendments to competition law or frameworks required? Can international cooperation play a role in addressing these issues more effectively? And I'll turn to Andrea to start for your ideas on any or all of these questions.
Yes, thank you, Matt. I'll try to be brief because I think we're close on time and people should be hungry by now. So in our experience, I think our legal framework is flexible enough to include the entrenchment theories in our merger review. And I think that's how it should be. And this is why. My view is I think the law needs to allow certain flexibility. It's sometimes battled in courts when these decisions go to courts or when companies challenge our law. Sometimes they want like a complete list and a set of definitions. I think that in the competition world and in competition policy and specifically in merger review, that is impossible. But then us as enforcers, I think we have a critical role in how you have a general law or a law that allows certain flexibility and room for interpretation, but then I think our job is to give predictability, to give certainty, to be consistent in our decisions. And there, I think also guidelines and sideline regulations play a very important role. So to be a little bit self-critical of our Mexican system, I would say I think the law has worked and has allowed us to review entrenchment theories in digital and in non-digital cases. But I think that what we are working, and we have to continue working, is to make our decisions consistent, predictable, in order for firms and for practitioners to advise their clients in what are the risks and what they can do and then what they cannot do. And then it's not just only our decisions, but also I think our guidelines, which are a very useful tool and should be a tool that's alive and that's updated consistently and regularly.
Thank you. Guillaume, you've already sort of made it clear that there's thinking going on in terms of your guidelines, and you've had some cases. Is there anything you want to add to the look-ahead picture on this issue?
Yeah. Obviously, I want to, because I think just to second what Andrea said is that obviously we have a legal test. Strengthening of dominance is in our law. We should apply it. And when we see new market realities emerging, even if they haven't been captured in your guidelines initially, you need to adapt, and you can do that. And legally, we have a right. It's not really departing; it's taking the experience and feeding that experience into competition enforcement. I'm saying that because there's a debate in court on booking, and where we were told you couldn't apply that theory because it's not formalized in your guidelines. Well, that would be a bit paradoxical that every time we have to change guidelines to address competition issues, but that's another part of the debate. Yet, flexibility is one thing, but you need to give predictability, rule of law. You know, it's important for investment, it's important for companies, so we acknowledge that, and we're at the beginning of that process that we will launch, you know, shortly on merger review. So indeed, that is, you know, a priority for us to be able to give some level of, you know, robustness and transparency on the type of factors that we think are relevant. And for that purpose, we'll have an inclusive process, a dialogue, you know, feedback from practitioners, from industries, from academia, and so on. But they are obviously very important questions. You know, going beyond these very general statements, I can see that there will be questions, actually, that we will ask during the public consultation on, you know, how should we handle these entrenchment theories, you know, in the new setting, in these, you know, complementary mergers, not, you know, horizontal ones is also relevant, but this is the real challenge. So, for example, the time frame we have to consider, you know, the short-term effects versus the medium to long-term effects, because there's a balancing act, and sometimes you can have an improved offering in the short term, very small to the risk to competition, and vice versa, you know, but this is a very critical question. Another issue that I mentioned earlier is, you know, to what extent do you need to rely on some kind of conduct? Isn't it also sometimes just a mechanical effect, as in a horizontal merger, for competition to be lessened and restricted? So then the question is, what is your framework? Is it ability incentive, you know, as we do it generally in a non-horizontal merger, or is it more, you know, more direct? Are they issues where you don't need to go into these potential conducts? That is a question, but I can see from our practice that this is very relevant, and it has an impact also, you know, on many features of the analysis. What is the level of interconnection between markets that you require? You know, we talk a lot about digital ecosystem. You know, is it really a prerequisite, or is it just a question of complementarity? Do you need many markets? Do you need a few? These are complex issues. I'm sure, you know, economists and lawyers will have different views on that, depending on who they represent or who they are, what they have in mind. And then what type of dynamic effects you were considering? You know, what type of effect in the market you're looking at? Tipping, you know, we talk about tipping very often. What type of customer behavior do you require? You know, consumer inertia is very important. Is it always, you know, very relevant or indispensable? And now, you know, you have the discussions around data accumulation, IP. You know, these are also important assets. Is that part of that conversation or not? So you see there are many open questions and topics. I think if we manage to have clarity on those relevant criteria, it will be a big, you know, big step forward and this will be part of the discussions also in these fora. I think that's the objective. So I think it will be very concrete and practical. This is not only a theory. That's what we need to be looking at.
Incredibly complex, difficult work ahead to delineate the borders, I guess. So what we've been talking about, sharing international experiences, which is what we do at the ICN, which is one of the great benefits of it. Is there a role, Rachel, for international cooperation beyond just sharing how we looked at one case in this type of, under this type of theory? Is there more we can do, do you think?
The answer is yes, there is definitely a role for international cooperation, and there are a few reasons why I say that. But just before I give you those reasons, could I say, as I've sat on both sides of the table, both as an advisor to an antitrust agency and in private practice, and I'm the non-governmental advisor on this panel, I really do commend the agency representatives on this panel for so openly recognizing both the value of flexibility but also the importance for predictability and transparency in this area. It's really good to hear such an open discussion. So the role for international cooperation, most definitely. It's very unlawyer-like to say most definitely in response to an answer. So for a number of reasons. First of all, a lot of the companies we're talking about here are global players with cross-border conduct, and that conduct has, for want of a better term, spillover effects outside particular jurisdictions, so reasons for jurisdictions talking together. And I think we would recognize, both from an agency perspective and from a company perspective, that fragmented enforcement that results in divergent or inconsistent answers isn't great from anybody's point of view. But, you know, and equally, cooperation and dialogue will show whether there are reasons for not necessarily having identical outcomes, different practices, different law, different procedures, different approach to remedies, which is often very important in this area. So those are three of the reasons in terms of enforcement. And then also, you know, this is entrenchment theory is one of these difficult developing areas, and so more heads are better than one. And in the ICN context, in the OECD context, with workshops, with roundtables, with recommended practices, that helps coming to good solutions in these areas.
Thank you, Rachel. What a great panel. There's obviously a great deal to be explored, discussed, debated on this topic, and we really have only scratched the surface in the hour we've had. Many of us around the world are clearly thinking hard about this and trying to come up with clarity and predictability in terms of how we're going to deal with these theories of harm going forward. But it's clear, and Rachel just put the exclamation point on it, we need to be talking to one another and learning from one another going forward. So for those of you who are interested in continuing to expand your knowledge about these issues, I would invite you on behalf of the whole panel to consult the 2 ICN recommended practices chapters that touch upon entrenchment theories of harm, the recommended practices chapter on non-horizontal mergers, and the chapter on unilateral effects in horizontal mergers. And take a moment as we wrap up to thank the member agencies and NGAs of the Merger Working Group for their work on these recommended practices and for their work helping us organize today's excellent panel. So please join me in giving a big thank you to our great panelists for a great discussion today, and enjoy lunch and enjoy the rest of the conference. Thank you very much.